Hi, welcome back to Finally Revealed. In this episode, I wanted to talk about what happens when a case is appealed. There are two kinds of appeals. There's an appeal on the record and there's appeal de novo. And de novo means new. And what those two things mean is if there's an appeal de novo, it means nothing really happened and you're starting all over. You're starting all over with evidence both documents, things, testimony, depositions, the whole 9 yards. It means that it's basically like a trial all over again. Usually a de novo appeal is when you start out at either a city court that's then appealed to a county court, or you're in a subset, a limited jurisdiction court where either, for example, small claims where you can't have an attorney and you think something went wrong and now you want an attorney, so you have to move to the next court, or a similar situation. So it's built in already because of the kind of case it is or where it is. So be aware of that before you start to do something, especially if you're going to do it yourself because you want to save money. If you have someone on the other side who is already not cooperative and nasty or belligerent, and and especially if they have any money to spend on an attorney, it may not be down and dirty quick like you think it is, or like someone might have told you you can take care of it yourself, go to small claims court. If the other side is going to then appeal it and make you start all over again, it's going to compound your frustration. So in that situation, evaluate who you're dealing with and just bring the case into the higher court in the first place. Now that's the de novo appeal. The other kind of appeal is an appeal on the record. This is the appeal that you most often hear about. And when a case is tried either to a court or to a jury, testimony is given, either recorded testimony in video, recorded testimony read from a written deposition, or a person coming in and telling the court or telling the jury the answers to the questions that are asked. And then documents are submitted and other types of evidence is presented. The trial court then rules on the evidence that's presented, and in whatever shape and form it's presented in, and either the court, if it's a court-tried case, the court evaluates the facts and determines the facts and then decides whether or not those facts match up either with a claim and that the plaintiff has proven their claim, or match up with a defense, and so there is no judgment for the plaintiff because the defenses were proven. Or in the case of a jury, when the jury is impaneled, the jury decides what happened in the case. They decide the facts, and then the judge decides the law. So that's at the trial level. And so the appeal anyone can appeal, anyone who's in the case, and there are certain deadlines and it's different everywhere. But one party may have won, but they didn't win on everything, so they want to appeal to get additional damages or additional claims that they think the judge or the jury made a mistake. If one side gets a slam dunk and wins everything and the other side thinks that was a mistake or wrong or something wasn't properly evaluated, then that side can appeal. And so then when the case is appealed from here, no one comes back and testifies, and documents and things are not presented again. What happens is the transcript, the court reporter has taken down all of the information, and that is bundled up in a transcript, and each side to the appeal designates what part of the record is going to go up on appeal. So then when it goes to on appeal, either to a court of appeals or a Supreme Court, or ultimately the U.S. Supreme Court, those reviewing courts are looking at not what happened in the main court as far as substituting their judgment for that court, the judge or jury, but they're looking first at whether procedural mistakes were made and whether the different things that people are complaining about is something that was discretionary with that jury or judge or not. So they're going to first look and say, can we even do anything about this either way? If it looks like it's discretionary, or if by law it was discretionary and it's enough, what they said that they based their decision on, there's enough there to go that way, they're going to not do anything. So, and then there are different burdens of proof based upon whatever the claims are and whatever the error is that is alleged to occur. So they're only going by what is in the written record, and they're not looking beyond that. They're not going to drive out to the scene of the accident or the scene of the crime or anything like that. It is at a more surface level and more cursory review. Now, depending upon what the errors are that are alleged, they can delve deeper into what happened, but they can't ask for more information. And so what I am trying to get here is that because a de novo case can be tried all over again, you're not stuck doing it the same way. You can start all over again. When the appeal is based upon the record, once that record is designated and sent, both sides can submit arguments on that record, but they can't change the record. They can't add anything to it. So I hope this was helpful to you. If it was, or if you learned something, give me a thumbs up. Share this with anyone who may be interested. Subscribe to see our other videos, and come back and see me next time. Thanks for watching.